So, hi everyone. Today's unit that we'll be doing is legal methods, and my name is Shazia Khan. We'll be looking at learning outcome today. So we'll go through the learning outcome we looked at. The last one was learning outcome 3, which was we looked at the hierarchy of the court structure, the personnel that work within it, the jury, the judiciary, and the organisations that work with it. Today we're going to look at learning outcome 4, which is to look at the issues around understanding the civil and criminal justice system and the alternative methods of dispute resolution. So we'll first go on to look at 4.1, which is to assess the duty and powers of the police, and what the issue is around what laws are in place in regards to arresting someone. So the main act that deals with the powers of arrest, which fall within a code, is the Police and Criminal Evidence Act 1984, which is referred to as PACE. PACE is short for the Police and Criminal Act 1984, and this act actually governs the major part of police powers of investigation, including arrest, detention, interrogation, entry and search of premises, personal search, and taking samples. Also part of the legislation are the PACE codes of practice. So when someone has the power to arrest, there are codes of practice that they must follow, which we'll go through a little bit later, which police officers should consider and refer to when carrying out various procedures associated with work. The Act attempts to strike a fair balance between the exercise of power by those in authority and the rights of the public authority, public body. So the PACE code is set out to try to be fair in regards to trying to be fair with the public as well. Firstly, to arrest you, the police need reasonable grounds to suspect you've been involved in a crime for which your arrest is necessary. So police are not allowed to just arrest you for no reason. They must have some suspicion, or they must suspect something that you have done in order for them to arrest you, or you've committed a crime. The police have powers to arrest, which I've just mentioned under the PACE Act, and anywhere at any time, including on the street, at home or at work. The police arrest procedure. So if you're arrested, the police must identify themselves as the police. They must tell you that you're being arrested. They must tell you what crime they have think you've committed, and they must explain why it's necessary to arrest you. They must also explain to you that you're not free to leave. And the reason behind this, they need to follow the codes of practice. If you're under 18, the police should only arrest you at school. If it's unavoidable, and they must inform your head teacher. The police also must contact your parents or your guardian or carer as soon as possible after your arrival at the police station. And the reasoning behind that is because the police need to identify that they're not, because you are not independent, you are a minor, so they need to bear in mind that they should contact your parents or a guardian. Police powers to stop and search your rights. The police can stop and search and question you at any time. They can search you depending on the situation. So if they suspect that a crime's been reported, or if you have any weapons, they can arrest you at that time. A police community officer, which is a PCSO, must be in uniform when they stop and question you. A police officer hasn't always have to be in uniform, but if they're not wearing uniform, they must show you their warrant card. Stop and question police powers. A police, when we mentioned officer, might stop you and ask you your name, what you're doing in that area, because if he's looking suspicious, then they will take on board that, you know, this person is looking suspicious and we need to arrest this person. also where you're going. And you don't have to stop or answer any questions. If you don't and there's no other reason to suspect you, then this alone can't be used as a reason to search you. So a police officer has powers to stop and search you if they have reasonable grounds to suspect that you're carrying illegal drugs, a weapon, as mentioned earlier, or stolen property. Something which could be used to commit a crime such as a crowbar. You can only be stopped and searched without reasonable grounds if it has been approved by a senior police officer. This can happen if it is suspected that there's serious violence could take place, you're carrying a weapon or have used one, and you're in a specific location or area. The right to representation. So how you get free representation. You must be told about your right to free legal advice after you're arrested and before you're questioned at a police station. You can ask for the police station duty solicitor, and they're available 24 hours a day and independent of the police. And this is all within the PACE codes, which I'll go through after, so you've got more of an idea which code applies to what area. Tell the police you would like legal advice. The police would contact Defence Solicitor Call Centre, which is DCCC. Ask the police to contact a solicitor if you have your own one, and you may be offered legal advice over the phone instead of a duty solicitor if you're suspected of committed a less serious crime, being disorderly. This advice is free and independent. So the PACE codes of practice are set out under 8 different sections labelled A to H. Each deal with different aspects of police duties as follows. We've looked a little bit at them above, but I just want to go through the codes with you so you have a better understanding. So Code A deals with a police officer's legal powers to search a person, which we looked at earlier, or any vehicle prior to making any arrest. They must make a note of the encounter. Code B, this outlines the police's powers to enter and search premises and seize any possessions found on a person or premises. The powers under this code are conferred to find anyone wanted by the police for questioning, arrest, or in relation to any crime, to find out any property or material related to the commission of a crime, or to find any children who should not be in local authority custody, where they have been remanded or placed under following a court order. Code C lays out the requirements for detaining suspects and how they should be treated and questioned while in custody. Includes the requirement to explain a person's rights while detained. So when a person is detained, it's really, really important that you explain to them why they've been arrested, because, they should know the reasoning why under Code C. Code D relates to the processes used for the police for identification of persons in relation to the commission of a criminal offence, and the police's obligation to maintain accurate and dependable information regarding criminal records. We then have Code E, which governs all audio recording of interviews carried out at the police station. Any interview concerning the following scenarios must be audio taped. Interviews with a suspect who is cautioned in relation to a criminal offence. So extra questions may be put to a suspect after they have been charged with a criminal offence. When an interviewer wants to tell a person after they have been charged with a criminal offence about other written statements or interviews with other persons. Then we've got Code F, and this covers the visual recording with the sound of an interview. An interview may be recorded visually in all circumstances outlined in Code E, or in the presence of a deaf or deafblind or speech-impaired person who uses sign language to communicate, or in the presence of a minor or anyone else who requires an appropriate adult, or in any case where a visually recorded interview is requested by the suspect of the representative. Then you've got Code G, Code G deals with the police powers to arrest any individual suspect of committing or connected with the commission of criminal offence. Police powers of arrest are set out in section 24 of the PACE code, as amended by Section 110 of the Serious Organised Crime and Police Act 2005. And they should only be exercised when absolutely necessary or they are at risk of interfering with the suspect's right to liberty, as in the Human Rights Act 1998. And Code H, with the final code, lays out the requirements for detention of suspects arrested under the Terrorism Act 2000 and how they should be treated and questioned whilst in custody. This includes the requirement to explain a person's rights while detained in connection with terrorism, and the code stops applying when a suspect is charged with an offence, released without charge, or transferred to prison. Failure, so these codes need to be adhered to by the police officers, and failure by a police officer to adhere to these codes of practice does not render them liable to criminal or civil proceedings. However, their failure to adhere to the codes can be introduced as evidence in civil and criminal proceedings. So it's really, really important that police officers fail adhere with these PACE codes, because if they are arresting someone, they need to identify the reasoning by why they are arresting them, and they need to follow the PACE codes. Now we're going to go on to the role of the Crown Prosecution Service, which is 4.2. So assess the role of the Crown Prosecution Service. So the Crown Prosecution Service, and it's referred to as the CPS, prosecutes criminal cases that have been investigated by the police and other investigative organisations in England and Wales. The CPS is independent, and they make their decisions independently of the police and the government. The CPS was recommended in the Royal Commission by the Criminal Procedures Report published in 1981 and was created by virtue of Section 1 of the Prosecution of Offences Act 1985. The role of the CPS is to objectively assess the police investigations and to prosecute cases satisfying the code for Crown prosecutors, first published in 1986, second edition in 1992, and third in 1994 for lay members of the public, revised in 2000. Prosecution procedure involves a set of papers being received from the police and allocated to a caseworker in the principal Crown Prosecutors Team 2. The CPS prosecutes criminal cases that have been investigated by the police, as mentioned, and other investigative organisation in England and Wales. They are independent, and their duty is to make sure that the right person is prosecuted for the right offence and to bring offences to justice wherever possible. The CPS decides which cases should be prosecuted, determines the appropriate charges in more serious or complex cases, and advises the police during the early stages of investigation. They prepare cases and presents them at the court, and provides information, assistance and support to victims and prosecution witnesses. Prosecutors must be fair, objective and independent. When deciding whether to prosecute a criminal case, the lawyers must follow the code for Crown prosecutors. This means that to charge someone with a criminal offence, prosecutors must be satisfied there's sufficient evidence to provide a realistic prospect of conviction, and that the prosecuting is in the public's interest. The CPS works closely with the police, the judiciary and other partners to deliver justice. So you've got the roles within the CPS. So you've got the Director of Public Prosecutions, then the Senior Crown Counsel, alongside the Executive Counsel, then the Crown Counsel 1, Senior Clerk, Crown Counsel 2 and 3, and Junior Clerk, and then Petty Officer 4. And this is how the staff roles. The caseworker makes an overall assessment by considering the two tests stated in the code for the Crown Prosecutor's CCP. The evidential test and sufficient evidence to provide a realistic prospect of the defendant's conviction on the charge. An objective test of whether the jury or magistrate is more likely to not to convict the defendant, and reliability and admissibility test of the evidence. CPS should be independent prosecution body in the criminal justice system with its own office, with its own staff, and taking decisions of the appropriate charges in criminal cases as well as prosecuting criminal cases. The Attorney General for England and Wales superintends the CPS's work and answers for Parliament. Although the Attorney General has no influence over the conduct of prosecutions except when national security is an issue or for a small number of offences that require Attorney General's permission to prosecute. So the CPS has 5 main roles on how it works and proceeds with cases. Firstly, the CPS look at the evidence and advise the police on the charge that the defendant should be prosecuted for. Then they review the case. They will look at the evidence of all the statements and make sure that they understand what the case contains. So the hate crime scrutiny group does this. After they decide this, whether to prosecute or not, they will take into account whether it's in the public's interest to prosecute or whether putting the case to the court would be a waste of time and money. If decided that the case is liable to go to the courts, they prepare it for trial. They will gain all the information that they have on the case and take it to the court for jury to evaluate. Finally, they present the case in the court. This involves members of CPS turning up at court and presenting all the evidence and statements that the police had given to them to judge and jury for them to make a decision. The CPS will often provide confidential advice to investigators on the viability of a prosecution in complex or unusual cases. This includes clarifying the intent needed to commit an offence or addressing shortcomings in the available evidence. Unlike in many jurisdictions, the CPS has no power to order investigations or direct investigators to take action. Whether the CPS has asked for advice or charging decision is entirely at the discretion of the investigators. The Crown Prosecution Service is responsible for charging suspects with indictable offences, and for indictable offences can be things like murder or rape, and all other criminal offences that lay beyond the prosecutional authority of the police. Police forces can charge suspects with less serious summary offences, common assault and criminal damage, with a low value, but cannot charge suspects with indictable offences without the authorisation from a Crown prosecutor. And this will only be in certain emergency situations where they can take it on hand themselves. As we mentioned, the code for Crown prosecutors requires prosecutors to answer 2 questions. The full code test: is there sufficient evidence for a realistic prospect of conviction? In other words, is there sufficient evidence to provide a realistic conviction? And secondly, is the prosecution required in the public interest? And these questions must be answered if there is insufficient evidence. So it's really important that they follow the code, because the code identifies the elements that they need to follow. Whether a decision to charge is taken by the police or the prosecutors, the CPS will conduct the case, which includes preparing the case for the court hearings, disclosing materials to the defence, and presenting the case in the court, as we've just mentioned. The CPS will be represented in the court from the first hearing through to the conviction, and in some cases appeal. All prosecutions must be kept under continuous review and stopped if the full code test is no longer satisfied or was never satisfied. If there's an appeal against the conviction or sentence is lodged by a defendant, the CPS will decide or not to oppose the appeal after considering the grounds of the appeal. If it decides to oppose, it will present relevant evidence and material to assist the appellate court. Exceptionally, the CPS has invited defendants to appeal when it is concluded that safety of a conviction was questionable, and for example, in the case of the undercover police Mark Kennedy. So now we're going to move on to the next slide, which is 4.3, to examine the latest reforms to the civil justice process. So Lord Woolf was appointed by the Lord Chancellor to carry out an extensive review of the civil justice system in the UK and Wales. He identified several problems regarding the old system and felt that it was in crisis. Lord Woolf found that the civil justice system remained crippled by high costs, excessive delays and complexities of trials. So, you know, there were problems that needed to be dealt with because, you know, they were taking time, cases were taking time, the costing was high and they needed to be dealt with. These problems have influenced major reforms which were intended to make enhancements in addition to create a more efficient and effective civil justice system. Firstly, the introduction of the case management was perhaps the most significant reform. Too expensive. So one of the arguments used against the former civil justice system was that it was too expensive. It could be argued that the system was in favour of the wealthier litigants, as many people were put off commencing claims as they were combined with considerably high litigation costs by lawyers. The new rules were enabled so that there could be fixed costs for cases on both fast-track and multi-track cases. Due to the complexity of civil procedures, lawyers with legal expertise are required in order to draft proceeding and give advice on evidence. The duration of civil procedures also has an effect on costs. To reduce the complexity of the civil procedures, Woolf ensured that the civil procedures were simplified by high costs by producing a single set of rules. Too slow and delays. Another problem with the civil process was that it was too slow and delays often occurred. Larger claims increased the time length and take longer to be brought to trial. The most delays were found in personal injury and medical cases as a result of lengthy process has had an impact on the financial burden on victims. In order to speed up the processes and avoid delay, Woolf introduced the case management to attain this. New landscapes of civil litigation. So Woolf is convinced that the future litigation will be less of an adversarial culture and more cooperative. Since the new civil procedure rules came into force in 1999, the position of the civil courts has improved due to the considerable changes made by Woolf, in spite of the problems still remain. The purpose of the CPR civil procedure rules were intended to eliminate unnecessary cost, delay and complexity and to underpin the civil justice system by making it more efficient. The aim of this rule is the overriding objective, where the CPR sets out the overriding objective of the whole system, and that rules should enable the courts to deal with it justly. Dealing with the case justly includes ensuring the parties are on equal footings, and also dealing with everything with efficiency. Even now, today, there is still a significant backlog of Crown Court cases, hitting more than 60,000 by September 2022. The highest rate, prisoners on remand for 50 years and court bindings in poor repair. So even now, there is a lot of issues with the criminal justice system. Is it too lenient? Is it underfunded? And there is still over 52% of respondents say that they have confidence in the criminal justice system and it's effective, and 53% said that they were confident that it is fair. So now we're going to go on to the next slide, which is 4M1, which is to compare and contrast the benefits and drawbacks of the different types of alternative dispute resolution. And alternative dispute resolution is something that is dealt with outside of court, and this is more used in nowadays, as it previously was not used before, but it's an external dispute, and where parties can settle the disputes with the help of a third party. So things like mediation will involve, and the reasoning behind this, that this works well within certain scenarios. So it's quite widely used. In Wolf's Access to Justice report, the use of alternative dispute resolution was greatly encouraged. It enables parties to explore ADR, introducing a set of rules governing proceedings in the High Court and the County Court. Enabling a shortened timetable for cases to reach court, and for lengthy trials and more case management by judges. Following the CPR, courts adopt a strict interpretation where people should be obliged to use ADR, and the case in regards to that is a case on the application of Cool against Plymouth City Council 2001, which you'll have additional resources on Moodle to have a look at that case. There are 3 different forms of alternative dispute resolution, which is referred to as ADR, and they're quicker and cheaper from ordinary civil courts. One of the ADR is mediation, and this is quite widely used by many, and the reasoning behind this is that people can mediate before they go to court, you know, and settle a dispute before it's gone to court, because, you know, disputes can be settled and it would be less costly rather than them paying so much cost to go to court. So the first one we've looked at is mediation, which consists of a third party, the mediator, who acts as a go-between parties to try to reach a mutually acceptable settlement. Mediation is a voluntary process. If parties should fail, the parties will have preserved their position, and it's confidential as well. And this is it is when an impartial person or a mediator trained in dealing with the difficult discussions between 2 opposing acts. He acts like a referee and tries to mediate the situation, and try to come up with a neutral resolution between both parties. It does work in some instances, and other instances it doesn't work, and then, you know, they're told they have to kind of go to court or mediate in a different way. The next one is another form is arbitration. And arbitration, it is governed by the Arbitration Act 1996 and involves an arbitrator who also assists the parties to resolve their disputes. Arbitration can occur in more than one way. Firstly, by commercial disputes, where contracts involving stating that disputes will be subject to an arbitrator. And secondly, parties intentionally agree to go to the arbitrator to solve their disputes. And this arbitrators use independent arbitrator, usually from the Chartered Institute of Arbitrators, to make an independent decision about the complaint. The decision the arbitrator makes is legally binding, so they won't be able to go to court later if they don't agree with the outcome. In many arbitrations, there's no court hearing. The decision is made by the arbitrator, is made from papers sent in and the evidence that has been presented and by yourself and the other party. They might have only given evidence in written form and the other party might be able to tell their story. Some arbitration schemes are free and they choose the arbitrator, but others you have to pay a fee for. And the next one is conciliation. And this is a method that involves a third party, the conciliator, who is independent by the parties. And the conciliator advises the parties to resolve their disputes. Conciliation is usually free to use and is often offered first because it's less formal than arbitration. Conciliation involves a conciliator, as mentioned, who focuses on what you and the other side want and tries to find a way of solving the problem that they're both happy with. The aim is to reach an agreed solution that suits you both. If you have a consumer problem, the contract you have with the trader might ask you to use their own conciliation service before you can use an independent arbitration. Should check if the charge for this service and how long it will take. Negotiation is the cheapest and quickest form of ADR. It involves a third party, the negotiator, who tries to resolve the dispute by negotiating. So he'll come up with, you know, a resolution, try to resolve something with the parties, with both parties involved. Lawyers continue to negotiate on behalf of their clients, even if the court proceedings have not commenced. Here, parties attempt to reach an agreement on the matters in dispute between themselves without the assistance of an independent third party. Each negotiator is identified with their respective side and will look at the case from their side's point of view. In addition to ADR, useful method of solving disputes between parties without having to resort to court actions. And that's what most organisations are now using, this way of resolving disputes rather than going to court because it's less expensive. It's less expensive as well. 4D1, analyse social, political and economic causes of miscarriages of justice. Miscarriage of justice. When we look at miscarriages of justice, there's lots of cases that involve miscarriages of justice in the UK. And, you know, it has been a thing that's been, you know, investigated quite widely. So a miscarriage of justice has been defined as a grossly unfair outcome in a judicial proceeding, as when a defendant is convicted despite a lack of evidence on an essential element of crime. And that was by Garner 2000, and you know, it identified that there are miscarriages of justice occurring in the UK. What causes miscarriages of justice? So causes of miscarriages of justice includes plea bargains that offer incentives for the innocent to plead guilty, sometimes called an innocent prisoner's dilemma. Confirmation bias on the part of investigators, withholding or destruction of evidence by police or prosecution. There are various cases of miscarriages of justice. of justice has occurred, causing lack of confidence in the criminal justice system. In criminal law, a miscarriage of justice can be defined as an outcome in a judicial proceeding that is unjust, unfair, or improper. The term, as we mentioned, a miscarriage is often times used to describe an error made by the court and results in the conviction of an innocent person for a crime that they did not commit. The most famous wrongful conviction was the Central Park jogger case, also known as the Central Park 5 case, which resulted in wrongful convictions of 5 young men of colour from underprivileged backgrounds. The alleged crime was attacking and sexually assaulting a white woman who was jogging in Newark's Central Park. Another biggest miscarriage of justice case is the post office scandal, more recent, and also the Hillsborough to the post office scandal, where they looked at miscarriages of justice in regards to them. It was quite horrendous in how miscarriage of justice was occurred, in regards to, especially the more recent one, which is the post office scandal. Another one, which is a most famous miscarriage of justice case, is the Birmingham 6, which remains one of the most notorious miscarriages of justice in the British system. In 1975, 6 men were convicted of bombing 2 pubs in Birmingham, which resulted in the deaths of 21 people. The Criminal Case Review Commission, which is referred to as CCRC, are the ones that investigate miscarriages of justice in England, Wales, and Northern Ireland. And if anyone thinks that they've been wrongfully sentenced or wrongfully convicted of a criminal offence and they've lost their appeal, they are allowed to apply under the Criminal Case Review Justice. There's so many other cases that I can mention historically as well, where there were miscarriages of justice. In the 1970s, there was a series of high-profile cases where the conviction was later recognised as miscarriages of justice. The first one, quite a famous one, is the Guildford 4, 1974, the Birmingham 6, as I've just mentioned, the Maguire 7, 1976, and Judith Ward, 1974. So what are the 7 causes of miscarriages of justice? The Innocent Project lists 6 contributing causes for miscarriages of justice. Eyewitness misidentification, where the eyewitness error is the single greatest cause of wrongful conviction nationwide, playing a role of 72% of convictions overturned through DNA. False confessions or admissions, government misconduct, inadequate defence, informants, so for example, jailhouse snitches, unvalidated or improper forensic science, so these are the causes of wrongful conviction, and it's quite a wide range of causes. And if you look at the one on mistaken witness, eyewitness is over 72% of convictions, while eyewitnesses' testimony can be persuasive evidence before a judge or jury. 30 years of strong science research has proven that eyewitness identification is often unreliable. And second, false confessions, in about 30% of DNA cases, innocent defendants made incriminating statements, delivered outright confessions, or plead guilty. And then you've got false forensic evidence as well, which since the late 1980s, DNA analysis has helped identify the guilt and extorted the innocent nationwide. So there are different, contributing causes for wrongful convictions. So today we've used a wide range of sources that you could look at. And overall, you know, we look at the criminal justice system as, you know, being unjust in some parts, but there have been loads of cases of miscarriages of justice, and quite famous ones that I mentioned. And academic studies have shown that the main factors contributing to miscarriages of justice, as we mentioned above, are things like eyewitnesses, perjury, vulnerable suspects, and that causes the issue of miscarriages of justice. And sometimes, you know, we look at the fact that this actually destroys someone's life. You know, the cases that we've looked at, such as, you know, the Birmingham 6, the Guildford 4, these were historical cases. And it is sometimes very difficult to prove that you are innocent. So that's why a review needs to be done. And, you know, if something has happened in regards to a case going in for miscarriages of justice, you have the right of appeal. The most recent case, which tried to read up about, is the post office scandal, which is quite a popular thing that's just been happening recently, where there has been lots of miscarriages of justice. So these are some of the references. We've got UK Police Officers' Rights, Powers of Arrest, which is the PACE code, Law Teacher, the UK Essays, and Data Government, and CPS, Prime Prosecution Service, that deals with the prosecutions. So we finished the session for today, which was on police powers, the CPS, and the issue with the criminal justice system historically, with the role of the changes made by Lord Wolfe in his report. And we also looked at the issue around miscarriages of justice. It's quite an interesting topic when you look at miscarriages of justice, because historically, since the 70s, even before, there were miscarriages of justice that have not been recognised up till now. But as things are changing, more cases of miscarriages of justice are being recognised and reported and appealed against. So we finished the session today. The next session you have is Learning Outcome 5, and I will see you at the next session. Thank you for attending today's session. Thank you.